our presenters are eager to get going with their presentations to you. I'm Ursula Tate. For those of you who don't know me, I've had the pleasure of advising the students during this semester in their Capstone projects. As I said last evening, and many of you know, there are some former Capstone presenters here this evening. This is the culmination not only of a long semester, but of a long 2 years. So the students have had the opportunity in their Capstone projects to really bring together the work and the research of interest that they've had over the course of 2 years of study here at UMass Boston to be able to really concentrate themselves on a specific policy-oriented research endeavor. So we have a variety, as the schedule of events indicates, of topics to present this evening. I want to take the opportunity to again thank the members of the Department of Conflict Resolution, Human Security, and Global Governance, Ronnie Lipton, for all of her help in this and all the endeavors, and Ragnetta, who is here this evening, and Lee Murphy, who was here last night, for all the work they did in not only getting the food together, but dealing with all the details that make an event like this possible. The students will each present for about 10 minutes their research for you, at least the primary components of their research, and then there'll be about 5 minutes each student afterwards for questions and answers. At which point then the next presenter will come up, but there should be plenty of time left over if you have any additional questions that you'd like to pose to the presenters, and to also finish up eating this wonderful spread that we have here. So if people are ready, and if you could turn off your cell phones, if you don't mind, if you haven't thought to do that, that would be very helpful as well. Okay? Thank you all very much.
All right. Hello, my name is Rebecca Feen, and my capstone was done on policy compliance and environmental adjudication in the international judiciary. I found in my study that the current system of international courts and tribunals were appropriate for handling environmental disputes. To kind of understand how I reached that conclusion, I'd like to give you a little bit of a background on the problem that started this research. And essentially that's the continued environmental degradation that's going on globally. And this is not due to the lack of policies, it's not due to the lack of efforts, but it's mainly because of compliance gaps and the complex nature of the environment and environmental management. Currently, we're seeing a growth in environmental policies and environmental agreements. In the international sphere, there's currently 1,100 international environmental agreements, 1,500 bilateral environmental agreements, and 200 other formal environmental agreements. All of these agreements cause sort of confusion about who has the authority over environmental problems and disputes, and it offers a lot of complexity that needs to be clarified. Again, I've said that part of the problem is compliance gaps. States are either unwilling or unable to adhere to the agreements that they've reached. And this is kind of where the role of the international judiciary comes in. Compliance by a judicial system can be, it's an enforcement mechanism, essentially. States feel the urge to avoid a formal litigation or judicial process, and therefore the judiciary offers an enforcement type of mechanism. Additionally, the courts also serve to identify and clarify problems in environmental regulation. They can look at rules and look at policies that have been created, provide clarification, and bring in other actors who may not have been included in the initial process of creating those rules. Finally, by making decisions on disputes, they're setting up the system to create international norms, which then establish international law. So, one of the solutions to the problems with compliance gaps and the complexity of the international environmental governance is people are proposing an international court for the environment. This has been proposed both by legislators, policymakers, and academics. Such a court could resolve some of the fragmentation that's existing in the environmental management system, and it would provide an enforcement mechanism that would hold states and non-state actors to policy compliance. The underlying theory behind an international court for the environment is that specialized treatment for environmental cases is needed. Certain aspects of environmental cases are unique, and the argument is that the current system of international courts and tribunals is not capable or is not doing its best to meet the needs of the environmental cases. So my research question when I started out with this capstone was, what is the current status of the international judiciary? Is it really not capable of meeting the needs of environmental courts? Does it have the capability to, and it's not? What are the trends? What are the gaps that we're seeing? Basically, does an international court for the environment need to be created? So to start off my study, I'd like to briefly introduce you to the international courts and tribunals that were included. All of these are permanent courts within the international judicial system, which could possibly hear an environmental case. Not all of them have. Some of them may never will, but these are the essential ones that I looked at. They have been classified into 3 different categories. The courts with universal scope, courts of the regional human rights courts, and then judicial bodies of regional economic integration. For the 3rd category, the economic courts were divided into 2 more categories, Europe and then Africa and the Middle East. The reason why I did that was it would help when I'm doing the analysis to identify trends. If you'll notice, there are no courts from any of the Americas. This is essentially because none of the courts in the system met my standards for the study. What I'd like to talk now a little bit is how I went about judging these courts in the system. The international courts were evaluated by criteria that relate to the environment and how well they're integrated into the system. And I've picked these based off of current literature in this area, specifically looking at other types of studies of international courts and national courts when dealing with the environment. There are 11 criteria, and the one I'd like to talk about right now, just as an example, since I don't have time to go over all of them, is the standing. Standing refers to the qualifications required of parties to bring an action or to participate in a case. Not all people have standing in a specific court. So standing can be divided up into states, natural persons, legal persons, international bodies or organizations, national courts, or the prosecutor of the court. The importance of standing when considering the environment and environmental disputes can be seen because environmental conflicts rarely arise just between states. In fact, more often than not, an environmental dispute or the environmental harm that is the subject of the dispute actually occurs among or harms the minorities or underrepresented people the most, and so it's important for them to have standing, to have their voices heard when you're considering these cases. Furthermore, it's come to be generally accepted in the literature that by empowering citizens and other actors, they actually become enforcers of international law. They hold a certain standard, and so if the state's not meeting them, they can actually urge the state to do so. So I'd like to briefly go over some of the findings and some of the trends that I saw. Essentially, one of the things that I was surprised about is how much of a consensus there was on some of these criteria. And by consensus, I mean all, or I would say all but one of the courts had met the criteria and had implemented it within their structure. This is generally found when you're looking at things like a standard rule of procedure, or if their agreements were binding, all the decisions are binding. All of the courts that I looked at had binding agreements. When there wasn't a consensus available or present, I noticed trends by classification, meaning the global courts all kind of thought and were structured similarly. The economic courts were all structured similarly. And this went as far as to when you break up the economic courts into their regional identities, you would see a difference between Europe and you would see a difference between Africa and the Middle East. I would like to just talk a little bit about the standouts. Two courts didn't follow the trends internationally or even within their own category. And the first one is the ICC. The ICC is the International Criminal Court. And the unique thing about it is that the court can actually launch investigations upon its own behalf. Most of the all of the other courts require a party to bring the case before the court. The ICC is the only one that can launch investigations and, in fact, bring a case before itself. And then the other standout is the WTO. And the WTO is sort of a mixed bag when you're looking at how it would deal with environmental cases. It could. It wouldn't be disastrous for it to hear an environmental case, but the problem is that it limits standing to only states. This excludes so many of the people that have a major role in environmental disputes that you might not get the best outcome. Additionally, its hearings are closed, which means that often the cases, even when they've been decided, there's no information about how they were decided or why they were decided in a certain way. It's just, this is the outcome of it. And that doesn't lend itself to transparency. All of the other courts, their regular function is open and public hearings. So, from all of this, the data that I've collected and the studies and the trends that I've identified, this is my recommendation. The current system is capable of handling environmental disputes. That's not to say that it does. The problem with my study is that it's only theoretical. I looked at the theory behind it, what it would be what would be ideal, basically, and then made judgments based off it. But that doesn't necessarily mean that's what's on the ground, what's actually happening in the court system. And so what I would see the next step is conducting audits or surveys of each of the individual courts, looking at cases, the participants, looking at the design criteria and the outcomes of cases, and sort of judging and seeing if the reality on the ground meets the theory. The importance of this when we're looking at how we look at environmental governance and compliance is that the argument to create a new international court for the environment is jumping steps. We're proposing something that we don't know for sure that we need. There's no data available that's compiled on environmental cases in the international judiciary system. Some of the individual courts provide some data, they provide all the documents for each individual case, but there's no analysis of all the data that's coming out of these courts. And so before we start creating new institutions and making new policies, we need to look at the reality of the situation. So, thank you. Any questions? Any questions? No? Did it confuse you all?
I'll ask a question.
Okay, ask a question.
You mentioned the WTO as a potential arbiter in environmental disputes. And I'm not an expert in the WTO, but my limited understanding is that, they regulate trade, they try to advance trade, and oftentimes environmental regulations are seen as an impediment to trade. Doesn't the goal of kind of solving environmental problems seem counterintuitive to the WTO's stated mission?
Well, first I'll say yes and no. One of the things about the WTO and how it is basically about trade is that environmental cases, environmental disputes are really about just the environment. It's sort of multidisciplinary, very broad subjects, and that's one of the problems with the idea of an environmental court an international environmental court is that it would be so restrictive. Who would bring the cases when they could go to someone that had more expertise in broader areas? As far as the WTO hearing environmental cases and it being against what they want to do, Not necessarily. Some environmental harm is so detrimental that it actually affects the economies, especially local economies, negatively. And so it's something that they have to balance. Is, you know, damming, say, the Amazon, which is an issue in Brazil, better for Brazil, but how does it affect the people farther downstream when it comes to their economies and to and trade in that way? So it's a balancing act. Any other questions?
Well, my question is also about the WTO. I mean, in that I'm kind of interested in the fact that WTO doesn't really have any authority on its own as an institution, and it relies on its members to sort of implement any sort of judgment that it passes down. So even if environmental standards were sort of incorporated in a substantive way that you feel is good for the environment, who would listen to the WTO?
That is actually one of the problems, not just in the WTO, but in the in the international judiciary in general. All of the states which sign on to participate in an international court do so voluntarily. Some of it comes along with other like if you sign on to become part of the EU, you're automatically under the jurisdiction of the European Court of Justice. So therefore, you have some obligation to appear before the court and agree to dispute settlement through that court. But when you're looking at like the WTO or the International Court of Justice or some of the other ones, the states have to agree to appear there. So by looking at the international judiciary and the role it plays in compliance, is that it's only one aspect of compliance, and that's important. It's not the only enforcement mechanism, but it's part of that, and so there's sort of more steps that it's involved as well. So thank you.